So unit 5, we will see some more topics. Okay, so there is one crime called as criminal intimidation. Okay, so most of the times you will see that this a person is charged with this crime along with something else. Okay, or might be a case is already running. Apart from that, there is another case filed for criminal intimidation. So what is criminal intimidation? Sometimes you will see maybe a person has committed a crime and he knows that so and so person was a witness and the case is being filed against him. Now he is afraid that this witness might go to the court and testify that I have seen this person commit the crime. So being afraid, this criminal, what he does is he goes to the accused person's, the witness's home, and maybe he threatens that if you go to the court and if you appear as a witness, I'm going to kill you, I'm going to kill your family, I'm going to cause you this harm, that harm. That is nothing but criminal intimidation. That's why we mostly see that maybe a case is already filed against the person and the person tries to threaten witnesses, victims, etc. In fact, sometimes while giving bail, releasing a person on bail, court will even specify that a condition in the bail bond would be that you should not meet the accused, you should not meet the victims, you should not meet the witness, or you should not meet the victim or victim's family until and unless the case is decided. As in, court tries to ensure that even though we are releasing you on bail, it should not happen that you are going and you are threatening those people. So you should ensure that you are not meeting the victims or witnesses, or you are not trying to tamper with the evidences, etc. Right, so what is criminal intimidation? It is provided under chapter 22 of the legislation, and sections 503 to 510 provides for criminal intimidation. So provides for offense which fall in the nature of criminal intimidation, intentional insult, annoyance. It's given along with. So section 503 to 510 provides for it. What is criminal intimidation? The offense is defined under section 503. The provision states that anyone who threatens any other person on the following grounds. Now, when we talk about threatening, right, threatening another person, there may be different types of threats that may be given. If the threat is related to any of these, it would be considered as criminal intimidation. Like threatens injury to the person, says that I will kill you, I will cause you this harm, that harm. Threatens injury to his reputation. I'm going to publish so and so text message that you had sent me. I'm going to publish so and so video. I'm going to publish so and so article, right? So that might be affecting reputation of a person. Threatens injury to his property. I'm going to burn your house. Like that also threats are given. Threatens injury to the person or reputation of anyone in whom the person is interested, like saying that I will kill your family members, I will kill this person, that person, somebody in whom he is interested or has some connection. If it falls under any of these, we will say it is criminal intimidation. Further, intimidation should be to cause alarm to that person. So if it is a witness who was planning to appear in the court and testify, the person would be alert, right? He might feel that, okay, if I'm going to the court appearing as a witness, this person might be really going to kill me or kill my family members. As in, it is creating an alarm to that person, and the person is going to reconsider whether I should go and testify in the court or not, or to make them perform any act which they are not legally bound to do. So a person is actually not legally bound to do something, the person would be said that now you go and do this. Maybe you had seen, maybe you are not a witness also, the person is saying you appear in the court as a witness, like fake witness. A person, you appeared and you say that you have seen this. So that is also nothing but criminal intimidation. Or to omit any act which they are legally entitled to perform. A witness is legally entitled to testify in the court, but he is prevented from doing that. It would also fall under criminal intimidation. The explanation to this section states that a threat to injure the reputation of a deceased person in whom the person threatened is interested will also be covered. So if somebody has died even a threat to injure reputation of that person would also be included. So if somebody's might be parents have died and the accused person comes and says that if you do this certain thing, I'm going to publish this certain thing about your, like the deceased person. Now obviously if it's family members or relatives or friends in whom the person is interested, the person is again going to reconsider whether I should do it or not. So that also would fall under criminal intimidation. It cannot be given as an excuse that it was affecting reputation of the deceased only. So in law we have a concept that nothing bad, we should say nothing bad about the disease. If you have to say anything, say good about the diseased person. So there is a concept like that. And that's the reason why reputation of diseased persons are also been protected, because even though the person has died, his family members, friends, relatives are still going to have some interest in protecting his reputation. So law also recognizes that. For example, A, for the purpose of inducing B to refrain from filing a complaint against him, threatens to kill B's wife. So this is a threat to cause injury to another person's body in whom this person is interested. That if you file a complaint against me, I'm going to kill your wife. A is liable to be punished for the offense of criminal intimidation. Okay, extent of nature of the threat. It is not necessary that the threat is direct in nature. In this particular case, court held that if a speaker at a public meeting threatens police officers stationed at a certain place with injury to their person, property, or reputation, then also he would be liable for committing the offense of criminal trespass. So it's not necessary that it should be direct in nature, pointed to one person directly in front of him. Even saying that in a public meeting that whoever are stationed in this certain police station, I'm going to cause injury to their person, property, or reputation, that also would be covered. There is another case wherein the accused allegedly threatened a female teacher by shouting that the teacher should be caught by her hair, kicked on her vest, and pulled out of the hall. Bombay High Court ruled that these remarks also constitute criminal intimidation. Okay, the nature of the injury threatened. There was this case wherein it was held that the threat of punishment by God could not be concluded under within the ambit of criminal intimidation. If the person who threatens is capable of putting the threat to execution, whatever threat the person is giving, that person should have the ability of executing it. If I say that I will kill you, I have the ability of killing the person. But if I say that, okay, you are doing this certain thing, God is going to punish you, I don't know whether God will punish that person or not. I don't know God exists or not. So I don't have the ability of executing whatever threat I have given, right? I don't have the ability of punishing that person on behalf of God. So it was said that in such situation, it would not fall under criminal intimidation. But if we are saying something which is within our control, that would be considered as criminal intimidation. Okay, is it clear?
Yes, ma'am. So this criminal intimidation, it is not only the case where some ongoing case or criminal case is there, then that person tries to uh, uh, threaten the other party, then only this is called as criminal intimidation. That is not the thing, no?
Mostly
Even
you would
general
see,
also, if
no, mostly you would see that some cases pending and, like witnesses, victims, they try to use it. But otherwise also it can be used. Like I mentioned, this one, saying bad things, that this teacher should be kicked out of the hall and everything. No pending cases there. This person giving a public speech saying that these police officers stationed in this police station will be done this. That's also no pending cases there. So most of the times you would see that this is used in that ways, but otherwise also criminal intimidation case can be there. Okay, so otherwise also you would see, sometimes you will see, there was one case of UP, there was like one self-proclaimed godfather who was alleged to have murdered few people. He even raped 2 3 girls in his ashram, and then case was filed against him. When case was filed against him, his supporters or his followers went to the victims and witnesses houses and threatened those people that if you go and appear, this will happen. In fact, they killed somebody also. Okay, that would also be criminal intimidation. That's like very common. But otherwise also, even without pending case and anything also, criminal intimidation might be there, wherein it's going to create alarm in the person, right? If the person in a public meeting says that the police officer stationed in this police station, they should be killed, they should be done this, some injury should be caused, those police officers, it's going to create an alarm in those police officers. They are going to be concerned about it. So that also would fall under criminal intimidation only. Yeah, so a threat to commit any of these, it would be considered as criminal intimidation. Okay, punishment for criminal intimidation. So punishment for the offense is laid down under section 506 of IPC. Now, when we talk about 506 of IPC, there are two punishments mentioned. Okay, two types of punishments are mentioned in two subclauses. The first thing is, in simple cases of criminal intimidation, whoever commits criminal intimidation, they would be liable for punishment for imprisonment up to 2 years, or with fine, or with both, depending on what is the threat given. If the person says that I will publish so and so defamatory article against you or something, it might be just a fine which can be imposed. Okay, so depending on the nature of the threat, it might go up to 2 years of imprisonment, or with fine, or with both. And this is a non-cognizable offense, as in police officers would need a warrant from the magistrate. Police officers cannot straight away arrest the person. It is bailable offense, and it is compoundable offense, as in parties can try to settle the matter, right? Amicable settlement is possible. It is compoundable, and it can be tried by any magistrate because punishment is lesser. And also there is a second part to it, which is if the threat is to cause, as in it is serious, and punishment is also more. If the threat is given to cause death or grievous hurt to the person, if it is to destruction of any property by fire, that I will put your house on fire, I will put your car on fire, that is nothing but like a severe threat. To cause an offense to be committed, which is punishable with imprisonment up to a term of 7 years, life or death. So if it is a severe offense wherein punishment is anywhere up to 7 years, life imprisonment or death, then also it would be considered under second classification. Okay, or attribute unchastity to a woman. So in such situations, the punishment would be more, which can go up to 7 years of imprisonment, or with fine, along with fine, or with both. So this particular offense is also non-cognizable, as in the police officer cannot directly arrest. It is again bailable, but it is non-compoundable. Parties cannot settle the matter, compromise the matter. Once it is filed, court only will decide on the case, and it can be tried by judicial magistrate of first class only, because punishment is more, 7 years, or it can go up to 7 years. So it can be tried by magistrate of first class. There was this case wherein the accused entered the house at night with armed with a knife. He threatened to kill the residents. This was held to be criminal intimidation under part 2 of the provisions of this legislation, because he threatened to kill the people over there. So second provision is like more serious, wherein punishment is also more. Okay, then there are some aggravated forms of criminal intimidation. We have section 507, which talks about criminal intimidation by anonymous communication. So in such cases, if a threat is given by way of anonymous communication, it can punished with imprisonment, which may extend to 2 years. The punishment is in addition to provided for the offense section 506. So depending on what threat is given, it would be applicable. If by anonymous communication threat is in to kill the person or something, section 506 is also going to be applicable. So it is in addition to the punishment. So section 506 also would be applicable, and this also would be applicable. So 2 years is just because the person was hiding his identity. Act caused by inducing a person to believe that he will be rendered an object of the divine displeasure. So essential ingredients are that any person who voluntarily either causes or attempt to cause any person to perform any act which the person is not legally bound to do, or to omit any act which he is legally entitled to do, by way of inducing or attempting to induce the person to believe that if he does not perform the acts asked by the offender, then either the person or someone else in whom he is interested will become or will be rendered by some act of the offender as an object of divine unpleasure. So in such cases, again, punishment would be added, which is 1 year, up to 1 year of imprisonment, or fine, or with both. So these are because the person is unduly influenced, right? Saying that you should do it, otherwise it would lead to divine displeasure, so you should do it. The person might actually believe on it and end up doing something. So additional punishment would be applicable here, 1 year. Okay, so this part you need to remember what all constitute criminal intimidation. The definition is given under section 503. Section 506 talks about punishments, wherein two types of punishments are being provided, one for normal criminal intimidation, another one for a threat, serious sort of a threat, wherein punishment would be more. Along with it, if somebody is hiding his identity or somebody is trying to unduly influence a person, their additional punishment is going to be added along with section 506. Okay, is this part clear?
Yes, ma'am.